What does a shareholders agreement actually contain? Now let's move on to the shareholders agreement itself, since this is really what you're interested in. Now let's consider, what exactly does a shareholders agreement contain? A shareholders agreement is a contract between each of the shareholders to ensure that they act in a certain way with respect to their shares and within the company. This creates a legally binding obligation between the shareholders that are not usually in place. In theory, there is no limit to the issues that can be covered within a shareholders agreement. As in most agreements, you can agree to do most things, except if they are illegal. At a minimum, the shareholders agreement creates core terms between the shareholders which cover a range of issues, including the structure of the senior executive team, who will be a director, whether there will be a managing director, how often the directors will want to meet, the voting rights of shareholders and directors, who can be a shareholder, who can serve on the board of directors, how much will the shares be worth if someone wants to sell or is required to leave the company, majority or percentage votes required for major decisions to be implemented within the company, the type of decisions that require a vote between the shareholders, for example, a major purchase of assets or a loan which is over a certain amount, or buying and selling shares of another company. What happens on a deadlock? This is an event where the number of votes are cast for and against a decision is equal. And how should a deadlock be resolved? Any banking, accounting, and auditing arrangements. Dividend policies. How should the profit be distributed to the shareholders and the investors? Capital contributions and what money or assets are being provided by each shareholder. Any obligation to provide any new loan to the company if cash flow is short in the future. The type of business that will be undertaken and the planned future direction of the business. Any directors' loans already outstanding to any directors. It may include director and key employees' salaries, or at least reference to their agreements. What happens when a party wants to leave the company, either as a shareholder or as a director? What happens if they die? What happens if they become bankrupt? What happens if they can no longer work or if you have to fire them? What happens if these things happen to you? Do you have a clear understanding about your succession planning, including sharing passwords, updating your will, etc.? If investors want to become directors, how do you make sure that a directorship is actually an appropriate post for them? What will trigger the agreement to be terminated? How will shares be valued in the event of a buyout or a sale to another party? What are each of the shareholders' obligations in terms of being restricted from telling other people confidential information or taking clients away? Is a director or shareholder restricted from setting up a similar business in competition, or able to ask employees to leave the company or work with clients when they leave? If you have an equal ownership in the company, then who will make that final call if you get into a dispute? And how do you work out how many shares to give someone based on the percentage? These topics won't be covered in order, but we will aim to cover all of this and more in this course by walking through the clauses of the shareholders agreement. Just take a minute or two to write down some of the things that came up to those questions so you have a stronger idea as we move through the specific clauses what your next steps need to be. The shareholders agreement. Now let's move on to the shareholders agreement itself. This document is a key document for all of the shareholders. both the founding shareholders and any new investor. It sets out the rights, the obligations, and the limitations of the parties and sets them in a legal document that is binding on everyone. Overview. A quick overview of the agreement itself. You will see that it is about 10 pages long. And the first thing that I would do if I saw an agreement like this would be to read the entire agreement. I wouldn't usually go from clause to clause. I would pick those clauses that I knew myself caused problems and check those out first. But for the purposes of this course, I will read out each clause and then give you a brief overview of each clause as we go.